Guy. Good morning, by the way.
Good morning, Kelly.
I am so excited.
You are?
I am so excited.
This is
Guess
so
what,
rare.
everybody? It's so rare that Kelly is excited to record clienting, but it's happening. It's for real. Partly excited because of what we're talking about today with PR. Because it was, I thought about going into PR in college. I didn't because it would have taken me an extra year to graduate and I was ready to be done. But I sort of regret that a little bit, like the putting out fires. And that's, I guess, what I think about with PR being so exciting. Anyway.
Yes, and today we are very fortunate to have the Edward Bernays of legal PR on our show.
What is that a reference to?
Edward Bernays.
What?
Guy with his communications history, just
Yes.
the knowledge train does not stop, does it, Guy?
No, the founder of public relations.
The grandfather,
Grandfather.
known as the grandfather of public relations.
Obviously,
Yes.
I didn't take enough classes in PR. But yes, welcome to our guest today, Wayne Pollock of Copo Strategies. Wayne, we're super excited to talk PR today. This is something we've talked a little bit around or about in ethics and that sort of thing, but haven't really kind of dived into and really pulled apart. So why don't you introduce yourself to our listeners?
Well, thank you, Guy. Thank you, Kelly, for having me. Congratulations on your 1 year of podcasting. I hope Guy got you a nice, big, calorie-filled cake or cupcake to celebrate the event. I'm a subscriber to the podcast. I think you do a fantastic job, you two, with the guests you have, and I hope that this episode will be as informative as the other ones. I am an attorney. I am licensed practice in Pennsylvania and New Jersey. I help other attorneys and their clients ethically, strategically, and proactively engage the court of public opinion, i.e. the media and the public, to help those clients favorably resolve their cases, but to also help attorneys build their practices by getting their name out there, increasing their prominence, and hopefully getting new client matters in the door. I have a public relations background. I worked in PR for 4 years. I then went to law school, went to work for a big law firm for 6.5 years. And I left my big law firm a few years ago because I saw a need in the market for attorneys to be helping their clients engage the media in an ethical, strategic, and proactive manner. My counsel to my clients, either law firms or actual legal clients, incorporates media strategy, legal strategy, ethics compliance, and defamation avoidance. We'll talk about that all today. And it's a unique practice because I serve as a consultant to law firms, but I also serve as limited scope co-counsel to clients. So I'm brought in as an additional attorney focused on media strategy and legal strategy. And by doing that, attorney-client privilege applies, which for PR people is an uphill battle when they are retained by a law firm to help with their client matters.
I love this. This is going to be so fun today. Wayne, thank you so much. Well, thank you for the kind words. Although I feel like a cake, if I'd got Kelly a cake, it would have been lost on her because Kelly is a very healthy human being.
I try. I mean, he is the one who every time there's sugar around, he goes, sugar is poison, sugar is poison. But you're right, I do try to eat healthy. Maybe you could send me, I don't know.
A fruit tart, maybe.
Yeah, a bouquet of dehydrated fruit. That's just beautiful.
You know what?
Edible arrangement.
Edible arrangement. Thank you. That's
go.
what I was thinking. Or just like a crate full of mangoes. I've been really into mangoes lately, so that would be my preference.
Awesome. So let's dive right in here. So when I'm kind of framing the conversation today, I love that how you just described how you help lawyers and how you work with even their clients. And there's kind of two big buckets that I'm curious about. The first is the aspects of litigation publicity. So things like, we get we're web marketing people. And so we get these questions about, should I have a different website up during trial? And what's the impact of what I put on my website on jurors? And so that's one big area that I'd love to get some of your thoughts and experience on. And then the other one is just tactical ways that lawyers can engage the media. For us, like, again, a lot of stuff we focus on is online. So things like HARO, help a reporter out, media outreach, and obviously, to state the obvious, we really focus on that in the context of how that impacts search visibility, because that's what we do. So I think this is going to be a great conversation. I think there's going to be a lot of valuable tips and actionable takeaways for lawyers having you. So thanks for your time. And I don't know, the specific question, maybe let's just start with kind of a narrative of some of the big issues that come up with your clients in the context of ethics and attorney-client privilege and trial publicity stuff that are kind of like the big, things that always come up that lawyers should be thinking about.
Absolutely. Let's take a step back and let's frame the idea of the court of public opinion.
Yes.
I define, and my firm defines, the court of public opinion as a group, or the group of people who may not be parties to a legal dispute, but whose perceptions of the dispute can impact how it's resolved and the reputation and prosperity of a litigant. So again, parties who are not involved in the case, but whose perception of the case can make an impact on how it's resolved and the prosperity and reputation of a litigant. So when you think about that, you start to see that all throughout the public and the audience, there are these groups of people that you as an attorney should be targeting with your publicity and with your public relations to get them to see the case and the world from your point of view and your client's point of view to help you resolve that client's case. So for example, you want to talk to the media. The media is the gatekeeper. The media has the biggest bullhorn. And when you're trying to talk to the public, you're gonna have to go through the media. Unless you are a celebrity with 3 million social media followers, most people need the media to communicate the message. But when you're talking about engaging the public, you're talking about perhaps the executives of an adversary. So you are a plaintiff and you're suing a large corporation. You want to communicate outside of your court papers that corporation, that defendant, is going to be in for a long haul because you have the kinds of allegations and the kind of story that's going to hurt that defendant as they go on. You're also going to want to talk to the public. Remember, the public one day might become a juror. And even though a trial is a rare thing these days, especially a jury trial, you have to remember the public, members of the public will be jurors someday. So you want to get out there ethically and strategically, and you want to tell your client's story, again, outside of court, away from the anonymity that often happens in court papers, because obviously most members of the public aren't witnessing court proceedings and aren't reading court papers. You want to tell your story publicly to help shape those jurors' perspectives in a couple years from now. We'll talk about the ethics of doing so. But remember, jurors like you and I and every listener here, they're human beings. And the first impression they have of a dispute or a litigant in a dispute is going to shape how they perceive every subsequent development. Even when a judge instructs jurors to disregard anything they hear outside of court, that's fine, and jurors will absolutely do that. But the impression left in their minds from a year or two ago, based on what they heard about a client, that's going to impact them. And I would say that's especially important if you're a criminal defense attorney or a white-collar defense attorney, and you have a high-profile case. It's going to take a few years or so to litigate and get through. And you have prosecutors who are often the most media-savvy attorneys in practice today, going to the mat and publicizing developments in your case and having a very cherry-picked indictment and cherry-picked press release. And the public reads these bad things that your client or clients allegedly did, and they have this opinion of, gee, what a snake. And you as the attorney have to figure out, how can I get a jury in a year or two from now to disregard that and focus on the merits of the case? So that's a kind of, I was all over the place, but the first things first, the court of public opinion is a group of people outside of a case that whose perceptions of the case can impact how it's resolved, and how a defendant, normally a defendant, how their reputation could be damaged, how their business interests could be damaged. So we talk about that, and then we move to ethical considerations. Two big rules that are at play here with ethics when it comes to attorneys talking publicly about their cases. The first is Model Rule 1.6, and however that might be interpreted by your local state bar, confidentiality of information. Obviously, we as attorneys don't want to disclose confidential information and waive privilege. But in addition, the ABA last year put out an ethics opinion, I think it's 480, that says when attorneys talk publicly about their clients' cases, they need to get approval from their clients, even when the attorneys will be talking about information that's already public. If you're talking about the claims in your client's case that's already public, you still need approval from your client to do so. That's one. Two is Rule 3.6, which is really the controlling rule here. Rule 3.6, trial publicity, essentially states that attorneys cannot make statements outside of court that they know will be communicated by means of public communication and could have a substantial likelihood of materially prejudicing an adjudicative proceeding. Substantial likelihood of materially prejudicing an adjudicative proceeding. And what the US Supreme Court has told us is that adjudicative proceeding is the trial. We do not want to interfere with a judge's ability to run a trial and a judge's ability to seat a jury based on what attorneys are saying outside of court that might not be admissible in court as evidence. The Supreme Court has also told us about 6 months, this was back in 1991, 6 months between a statement and a trial is enough time for any taint from that statement to dissipate. And on top of that, there are a number of safe harbors in Rule 3.6. Attorneys can always talk about the contents of a public record, always talk about their claims, offenses, or defenses, and they can rebut bad publicity that wasn't created by them. So the ethical rules, even though I'm just touching on them, actually empower attorneys to talk publicly about their cases, because the rules say you can always talk about the claims, offenses, and defenses in the case. You can always talk about the contents of a public record. What the ethical rules are concerned about is you, Guy, talking about information or evidence that might not be admissible and screws up the entire jury process, because now jurors are reading things in the newspaper during trial that could not come in as true evidence as part of the case.
Right. That was great framing, by the way. And I have to first disclaim, I am not an expert on this stuff. But man, this is a crock. Like, I just can't. I think back to, I would love to see judges from 50 years, 100 years ago, in the age of social media and the internet, and their reaction to what I see from lawyers on social media, or even in the news, even here in Chicago, when I see a lawyer on TV, and I'm like, there is no way that this would fly back then. And I feel like the entire judicial system has kind of shrugged and said, what do you want us to do? We can't lock down the internet while we're leading up to trial, but you see this stuff happen all the time. And in so many cases, and will be the second kind of half of our discussion today, it's so clear that the lawyer is doing things intentionally, more as a reflection of their own marketing message to get their next client than they are to actually serve as an advocate for their current client.
Yes, paging Michael Avenatti. Exactly.
I'm not saying anybody's name.
Right.
But so I find this fascinating, and I just think it's a real problem that I don't know. I mean, again, I'm not a judge. I'm certainly not a U.S. Supreme Court justice. I'm not an expert on this stuff. But I as a quasi lay person, I suppose, I flip on the TV and you see these lawyers up there, criminal defense cases, and you're like, they're either intentionally doing it to make it virtually impossible to have a trial in the area, right? They get it thrown somewhere else, or they're doing it because they want to be the best criminal defense lawyer around, and nobody's messing with them. And so I find this stuff fascinating as at the intersection of trying to apply these ethics rules and where communications technology has taken us, which is basically seamless and the judge, I don't know if I'm a judge. I'm like, I don't know. What do you want me to do?
And that's where you see the interplay between legal strategy and media strategy. All too often, lawyers are focused solely on the legal strategy, and they cannot see that their case and their client has to deal with practical implications about the case that goes outside the four walls of a courtroom. And on the flip side, most PR people who know the media, they have a very media-first mindset, which is great. But sometimes when you have a media-first mindset, you end up hampering your legal strategy. For example, let's say you have a great opportunity to get a client on Dateline NBC or 2020 or the New York Times. Really great opportunity to get the word out about this wrongdoing. But your client wasn't prepped well enough. And your client makes a statement that's great for the court of public opinion, but could be used against him or her down the road at a deposition or during trial by somehow talking about liability or causation or whatever it might be. Well, now you've just cut off your nose to spite your face because you've got great publicity, but now your entire case is undermined because of something a client said or even a lawyer said. So you see right how there's a litigation strategy and a media strategy that have to run parallel, because when they're out of sync, they end up impacting negatively the other. And to the ethical concerns, the big issue is the balance between your and my and every other attorney's First Amendment rights to advocate on behalf of his or her client and the state's rights, the state's interest in fair trials. And you can't mess with either of those. I mean, they're both very strong arguments, and that's where the Supreme Court came out on its case, Gentile versus State Bar of Nevada, 1991, the one Supreme Court case to talk about Rule 3.6 and language of Rule 3.6. There's a balance there that the Rule 3.6 language is constitutionally permissible because it gives attorneys enough leeway to talk about their clients' cases, but not so much that it railroads the state's interest in actually being able to make sure juries are seated properly and are not privy to inadmissible evidence that comes in through the media.
Well, unfortunately, if they were exposed to that 6 months later, they're totally going to forget it.
Absolutely. And let me throw one even further at you. I'll give you a real kind of a brain teaser here. That was 1991. This is being recorded early 2019. On one hand, with the fire hose of information that we all drink from now, I don't remember what I read 2 weeks ago. So you think that 6 months probably has shrunk down to a month or two, theoretically, if it was ever litigated. On the flip side, there were no search engines back then. So if I make a statement on February 1st, 2019 about a case that's going to be tried in February 2021, that's fine under the current ethics guidelines. But if a juror on January 30th, the eve of trial, Googles my name and sees me make a statement about that case, well, does the power of that statement go back to when it was made 2 years ago, or is it suddenly more powerful because a juror is reading it again the night before? So again, an example of technology way, way past where the law is. But it's interesting to think about as lawyers talk publicly about their cases, these kinds of concerns. And I should have said this earlier. When we're talking about attorneys engaging the court of public opinion, you could be a solo attorney, you could be a big law attorney. This is a tool that attorneys can use regardless of where they're at in terms of size of law firm, in terms of budget. You could do it yourself. You could hire someone to do it. You can do something in the middle. And most litigation practices are going to have the capability and the need for this. Criminal defense, absolutely. White collar defense, absolutely. Real estate, zoning, getting along with your neighbors, shaping the court of public opinion when it comes to your client who wants to build a new condo. All excellent areas where this will come into play. Estates and wills and trusts, maybe more of a marketing thing, not really going to be a focus of helping to get your client's cases resolved. Same thing with maybe family law, though there sometimes are high-profile divorces. But generally, if you're a litigator, a trial attorney, or you have the kinds of legal disputes that involve public documents, that's where you really can use the court of public opinion, again, as a tool for your client and simultaneously as a marketing tool for you and your firm.
Right. Well, I mean, as a former plaintiff's lawyer, I mean, this stuff came up all the time. And even like you said, it could be a small case in a very local community. But let's face it, the insurance companies are spending a lot of money shaping the court of public opinion about the impact of frivolous lawsuits and bloodthirsty trial lawyers on your insurance rates. And you know, this is something that comes up at AAJ conferences and in that community. But it's extremely applicable. I mean, anytime that there's, I'm trying to think of examples of where it wouldn't apply. It's almost like any time that if it's news, then this matters.
And-
But on the flip side,
No,
on
no,
the
go ahead,
flip
Kelly.
side of the insurance companies, there are now all of these news stories that I'm seeing, at least, where insurance attorneys who work against insurance companies are getting a lot of PR for their clients, where they're like, oh, this isn't covered, that isn't covered. It's this, you know, sweet 16-year-old girl who has a brain tumor and like she just needs this experimental trial, but she's getting denied. And they get all of this amazing PR, and then the insurance company relents and goes against it.
Absolutely.
So I think it's starting to work for both sides now. I'm seeing more, at least in my recollection of the news.
Well, and you make a great point, Kelly. You have to be proactive here. Attorneys need to be proactive with this, with the practice and with engaging the court of public opinion. For the vast majority of reporters, interesting, newsworthy cases are like needles in a haystack. The only way reporters learn about newsworthy items, they either find out on their own or they're told. And you cannot expect as an attorney, based on PACER and based on the state of the court, based on the state of state court systems, they're not searchable. You can't type in sexual harassment and salacious details and a celebrity and get something. So attorneys need to realize that most of the time, reporters don't know about these cases. But you can, we'll talk about the defamation aspects of doing this, but you can, as an attorney, reach out to a reporter and give them a heads up. This case is being filed, it has been filed, and explain why it's newsworthy. No attorney expects a judge to find the cases that support the attorney's position. No attorney would take a stack of cases and email them or put them on the judge's desk and say, here, judge, it's all in our favor, go ahead, take a look. No, you find the cases for your client, and then you frame them in your papers in a way that compels the judge or the jury to find for you. It's the same thing when you're engaging a court of public opinion. You cannot rely on reporters to find interesting cases that you're working on. They don't know they're there. You need to not only inform them of the fact that this case exists, but you need to also explain why it's relevant. This is an issue where insurance companies are denying their clients clear legal rights to recovery. And this is an insurance company that just had $1 million annual retreat and it pays its executives XYZ. On the flip side, you need to be sure as an attorney, if you're on the defense side, that you have the ear of a reporter who's covering your client's case. So again, let's go back to the example of a white collar case. You need to be able to you need to ensure that that reporter will call you for comment when the prosecution or some other entity does something of note in your client's case. If you don't have that relationship, you can't be assured that you're going to have an opportunity to tell your client's story. And I laugh when I see this. No attorney would dare miss an opportunity to file some kind of opposition paper or reply brief when given the opportunity to do so. And yet, when a reporter calls an attorney, so often they decline to comment, and or they'll say something, we'll let our papers speak for themselves. But no one's reading those papers. That article, that article that is being written about your client's case is an opportunity for you in plain English to connect some kind of theme that you have for your case to the greater overall public opinion and the greater overall public consciousness. And when attorneys refuse to talk to the media, they are doing themselves a disservice, but more importantly, their client a disservice. There are plenty of clients who want their stories told, but have such low expectations of attorneys because most attorneys don't know how to do it and aren't willing to do it.
Yeah, we talked about, a good example of that is when we had Greg Siskind on, he talked about breaking things down on Twitter. Like there's a new immigration policy that comes out and he breaks it down into plain English, non-lawyer speak for reporters on Twitter so that then he's the person they know to go to because he's told them exactly what this stuff means. Whereas when you go and you file something like, it's a 200-page document that you're filing with the court and with the judge, and reporters they don't have time to read 200 pages, and they didn't go to law school. Usually they don't know what all of those things mean. So it's incredibly important to do exactly what you said.
And then you go next level, and you have on background conversations or off the record conversations with reporters, and you walk them through the pleadings so they have an understanding. You're not necessarily trying to persuade them that your client's case is right. But if you have a 200-page filing with 300 pages of exhibits, good luck with the reporter being able to dive down and find what they need. And that's important because, as you know, and as we see with court papers all the time, sometimes the most important nuggets are hidden under lots of layers of excess. And you need to be able to explain to a reporter the gist. And you can do that on a conversation, video chat, live phone conversation, in ways that you can't necessarily do that with one email, or it would take you 3 hours to write the email because you're going into detail about certain things. So absolutely, Kelly, you need to be able to explain either in your writing or your communications, one-on-one communications with reporters about the actual case and the underlying themes.
I want to know, kind of taking a different look at using PR. There are several solo and small firm lawyers that are kind of in our universe here, and we've talked about them before, like Kimberly Bennett and Jess Birkin, who are doing a little bit beyond just lawyering, and they're taking kind of an approach of, okay, small business or nonprofit that I work with, here are some other things that you need to consider as a business. So how do you kind of work specifically, I guess I'll take Jess Birkin as an example, as a nonprofit attorney. And I'm just thinking of, how does someone like her bring the element of PR in?
Well, so there's a couple ways that she could do that. If you think about an attorney in your practice area, you can attempt to get publicity for yourself and your practice when something in that legal area is newsworthy. So for example, whenever there is an unfortunate duck boat crash, Ride the Ducks, that's across the country, you'll see that when there's breaking news of that happening, there will often be either a plaintiff's attorney from the region who's commenting on the case, or some other attorney who has sued Ride the Ducks entities before in other unfortunate accidents and tragedies, chiming in as an expert. If you are a nonprofit attorney, if you're a family law attorney, if you're a wills and a trust attorney, you should be on the lookout for what's known as newsjacking opportunities for you to either write a blog post about your legal spin on the situation and have that found by a reporter, or you call up a reporter you've been talking to frequently or occasionally, and you say, hey, here's an interesting angle about that Ride the Ducks crash, or so Prince died without a will. Well, let me give you some ideas of how people can avoid those kinds of problems when you die without having a will and estate's plan in place. So if you're a nonprofit attorney, you could certainly attempt to have an eye out for when there's, for example, allegations of nonprofit fraud, or there's a merger of two nonprofits. You have the expertise to handle fraud, presumably, or a merger on your own. You take that expertise and you apply it to a case that you're not involved in, and you come across as an expert. And I will say this, when you are in the news, when you are in media outlets being quoted as an expert, the phone calls and the emails come. They're not going to come in a boatload. You won't be in the New York Times tomorrow and have 3,000 calls. but you will get phone calls. You will get inquiries from people who see you either advocating on behalf of a client or just showing your expertise when you're talking about a subject matter that's not pertaining to a particular client. People see you in action. They see you as an advocate in action. And while they might not ultimately hire you, that's, I guess, for you to decide after they make the phone call and how you handle your kind of new lead intake. But you're positioned yourself as an expert through this process, and you didn't have to pay any money for that click via PPC. You didn't have to worry about your Facebook ad. You have this social proof. So attorneys who may not have the kinds of litigation matters where those matters in and of themselves may be generating publicity, they can be on the lookout for issues that might be on the periphery or at the heart of their legal practice, and comment on them and see if they can get into publications that way. I would also suggest that it could be an email, introductory email. Hi, I'm so-and-so. I practice law in XYZ town. I handle nonprofit law. I know you're a general business editor, a business reporter. If you ever have come across a nonprofit facing some legal issues, I'd be happy to walk you through it. Sometimes you don't have to wait. Just go ahead and introduce yourself, to a reporter, and you never know what might happen.
Yeah, one of the things that we found really effective from a search standpoint is whether you call case summaries, hosting some of the opinions, but writing them up, use the actual case names in what stuff that you're publishing on your site, and especially on a local level, that stuff will come up in search. And so when reporters are using Google to do their research, they end up finding what you wrote, and whether that's an interview or a quote, or they link back to your site, which has the SEO value. Extremely powerful, quote unquote, buzzword content marketing approach.
Absolutely.
To PR that we've found. Wayne, I'd love to get your opinion too, since this is something that's come up in the past. And I'm wondering if this is less true today, just because of social media and the age of instant information. In the past, local lawyers that might want to put together a media strategy or do something media-wise from a marketing standpoint would have to probably contact a local PR firm because they had relationships with the reporter. At least that's what the PR firms were selling. Is that still true today, or is it more of, you just recommended, hey, you can just reach out to the reporters or tweet the reporters and they're more responsive to that? What's your tactical advice for lawyers that, might not be able to put, they don't have the budget to put together an entire strategy? What are a couple tips you'd have for trying to engage with these reporters on a local level?
Sure. So I think that the idea of me, a PR person, I have relationships with reporters, I think that's a little bit more sizzle than steak when it comes to the actual process. If you know how to engage a reporter and at least tell a story, I'm sure you do, because if you're an attorney, you tell stories all day, every day. You don't need to have the relationships. What trumps relationships are stories. And the analogy I would make is, you might know a judge, you might know opposing counsel, and you and opposing counsel being friendly, it might get you a couple days extra on a deadline if something came up with your kid being sick. Same thing with the judge. You might get a little bit on the gray areas. But opposing counsel isn't going to say, I haven't seen you in forever. I'm just going to drop the case. It's so great to see you. Let's grab a drink. Right? No attorney's going to say that. No reporter, even if you are chummy with a reporter, no reporter is going to say, wow, this article is a stinker. This lawsuit has no news value, but I'm going to squeeze it in anyway. They're not, because their editor is going to say, what the hell are you doing? So relationships are good on the periphery, but that shouldn't stop an attorney from either hiring someone or doing it themselves, because what counts as a story. I've helped clients get media coverage across the country because I knew what was newsworthy to the reporters and how to tell that story. So the first thing attorneys need to be doing is they need to be active readers of news articles about legal disputes and lawsuits. That actually would have been the homework assignment I would have given if you asked me to give the listeners one. For the next week or two, every article that you see or every headline you see as you're scrolling your phone or in the newspaper about some kind of legal dispute or lawsuit, read the article and look at how the reporter is reporting on the article, who is being quoted, what is the source material. You as an attorney will start to see how that sausage is made. I think it would be helpful for attorneys to find the reporters in their area who are likely to cover legal disputes based on their practice. So for example, if you are in a big enough media market where your local newspaper has a federal courts reporter or a state courts reporter or a criminal justice reporter or a law reporter, whatever it might be called, email them. Introduce yourself in the span of about 2 or 3 paragraphs, if that. Explain who you are, what you do, and how you could help the reporter. If you have a more specific practice, maybe you do special education law, maybe you are a corporate attorney for pharmaceutical companies, or maybe you sue pharmaceutical companies. Well, now you could look at your local business reporters, your local education reporters, and you can go to the trade publications, the vertical publications. Education Week, for example, is a national publication that covers the industry of colleges and universities and education. There are many, many pharmaceutical publications. Find the people who are writing about lawsuits. And the easy way to do that is to just go to those publications' web pages and search for the term lawsuits. You'll find reporters who are covering those cases. And again, introduce yourself, explain what you do, and tell them that if they ever have questions about a legal case, you'd be happy to review some court papers for them or walk them through what the court papers might say. By positioning yourself as a resource, you will hopefully endear yourself to that reporter. And when they have a need for a source or someone to comment on a topic, they come to you. Hello, this sounds just like marketing, because it is marketing. It's a different kind of marketing. As opposed to your prospects and your referral sources, you want to get reporters to know, like, and trust you. And as you see the world through that prism, you'll start to see that reporters aren't these people who are necessarily behind force fields that you can't reach out and touch. They are human beings who struggle with understanding certain topics because they're not experts in all of those fields. And you can really endear yourself by being a resource to these reporters. So I would say actively look at articles about lawsuits and legal disputes to get a feel for how they're reported. And then introduce yourself to the people that you think, based on your practice and where you live or where you practice, are the kinds of reporters likely to cover legal cases that you either work on yourself or who could use you as a resource when necessary.
Yes. Oh, I love all of this so much. And for the video recorded version, everyone, we are nodding our heads furiously this entire time. Okay, so I have one last question. And this came from a conversation I had this past summer with Sarah Smearage and Jane Clausen of AROG. And I was kind of talking with them just about different lawyer marketing stuff, even though they're not in marketing, they're at AROG Insurance. But they were talking about how lawyers have a PR problem. And there's just this obvious, the public opinion, the perception of lawyers is really negative, typically, kind of the stuffy, out of touch, very aggressive, all of these, all the terms that you kind of joke about when you think about lawyers. But in reality, it has become this PR problem where people are looking at lawyers as untouchable or just all the negative connotations. So how are lawyers using PR, not just for clients, not just for resolving cases, but also to change their own image in the court of public opinion?
Well, I think many attorneys are following the advice that you and Guy have given about becoming more accessible by going on social media and talking about what makes you a human being, and not just that you provide aggressive representation at a cost-effective price. It's giving people giving the public a sense of what an attorney actually is as a human being. I think that attorneys can position themselves, and they try to position themselves, and you see this all the time, with particularly coded advocacy based on their market. So for example, you see plaintiffs firms who, the smart ones and the savvy ones, position themselves as taking on the big corporations, and they position themselves as helping the David against the Goliath. Well, many of those plaintiffs' attorneys have private jets and arguably are the Goliath in certain social circumstances and situations. But nonetheless, from a legal perspective, when you're taking on a big multi-billion-dollar international corporation, you are the David against the Goliath. So I think attorneys try to position themselves as helping their clients do something. It's not just that we provide aggressive representation or that we get back to you promptly. It's that we help you do something. We serve a role that you and that society needs. On the flip side, you've got defense attorneys, criminal and otherwise, who say, look, our clients are the victims of untrue allegations. They're the victims of opportunistic prosecutors or plaintiffs who are seeking to either throw the book at our client for political reasons or try to get a quick buck off of our clients. We want to protect our clients, excuse me, from these unlawful attacks. And you just see the kind of dueling narratives play out. I think attorneys can get around the PR problem by being more accessible. And you see this with, again, the things that you say and that are currently the trends in legal marketing. When a client comes in, either for an intake interview or to meet the attorney, if the attorney comes out as warm and personable, that's good PR. That's just good presence and good PR. That's different than kind of the attorney always talking over the client and not asking the client about themselves, what they like to do. It's amazing the benefits an attorney could receive from a client by simply asking the client what they need, what they want, doing a quick look on social media and seeing they're a big fan of, I don't know, some sport or some activity or Disney or some other kind of cultural item or icon, and chatting them up about that, talking about their family. So I would say that, Earth Day slogan is like think local or think global, act local. I'd say that with PR. Think about the overall impression that attorneys might have, but start with your everyday interactions with your clients. And if you come across as warm, slowly those dominoes will fall and the perception of the ice cold, unpleasant attorney will hopefully fall to the wayside.
Fantastic advice. So speaking of stories, as we wrap up here, let's talk about your story. So you were a big law lawyer, you had a public relations background, you founded Co-Post Strategies, which is Court of Public Opinion. And I'm so curious because it's such an interesting area and such a seeming need for lawyers. Tell us a little bit about the types of things that you help lawyers with. I think of, again, I get stuck in my, I'm a solo plaintiff's lawyer and I've got a case. I'm not very, they didn't teach me PR in law school. Is COPO a place I can come to learn, to get trained? Is it only for specific engagements? Tell us a little bit how you help specifically lawyers in that are situated like that, where it's like they just want to learn more and they want to get better at this, but they're not really sure how to get started.
Yeah, well, thank you. I was a big law attorney, and I saw over the course of my career at my law firm a trend. And that trend was that the attorneys I worked with and the attorneys I worked on the other side, opposite sides with, and even attorneys outside of my universe, I saw them fail to have an understanding of the power of public relations and publicity in their practices. And they didn't understand how it could help them, and they certainly didn't understand how to use it. And I did some research, I looked around, and there are PR firms out there, some of them who employ former attorneys, who do very nice jobs of public relations for law firms. But I didn't see I didn't see PR people or attorneys who approached a client's court of public opinion issues from both a legal and media strategy perspective. I didn't see anyone claiming to know the ethics of talking to the press and ethical considerations. And I damn well didn't see anybody know about defamation and talk about how defamation could be an aspect of this whole process, which we have to talk about before we end, because it's important. But anyway, so I looked around, I saw no PR people doing this. I saw no attorneys doing this. I said to myself, damn, I'm going to have to do this myself, aren't I? So I launched my firm a couple of years ago to really bridge that gap between law and PR. I help law firms. I help clients, depending on the situation. Law firms tend to hire me to help with ongoing PR campaigns. I am helping those law firms consistently go to the media about their cases and position their attorneys as proactive experts on certain subject matters that the attorneys might work on. I help my individual clients. Again, I serve as limited scope co-counsel to clients who hire me in connection with their legal dispute. I am the second attorney. I'm not appearing on any papers. I'm not appearing on the docket, but I'm there providing legal strategy in the form of media strategy. Those clients tend to be higher profile clients. They tend to be white collar professional clients who need a little bit more specific guidance on the court of public opinion, and so do their attorneys, because they're involved in high profile cases that the legal strategy needs to incorporate media strategy. So for example, I represent with a couple other attorneys 3 whistleblowers who filed a high profile lawsuit against a well-known government official on the East Coast. And the reporters need to know, the attorneys and my clients needed my guidance because they're going after someone who is a political appointee, who has a powerful PR machine underneath him. So they needed someone to understand how to handle that. Another client of mine was the leader of an educational institution that was fired by the board, and the board of her institution got a good couple of days of favorable publicity for her dismissal. She needed help because the bad publicity was going to hurt her severance package options, because the institution said, well, look, all these things that they're saying are true. We're not giving you what you want. Her attorney found me and hired me as co-counsel to this client, and we turned around that narrative quickly, got to be more favorable publicity, and ended up getting a favorable severance package for that client. So there are opportunities and there are instances where attorneys can do this by themselves. They can do it with me or with someone else who knows the media, but they have to be thinking at all times about media strategy, legal strategy, ethics compliance, and defamation avoidance.
Awesome. Fantastic stuff. And where can listeners go to learn more about some of these topics? You can point us to your site. Sure. Or anywhere where you prefer to be engaged with online?
Yep. Copo Strategies, COPO strategies.com is my website, my firm's website. You can find anything you need there. We have free guides. We have a free communications audit. We have a coaching program. Go there. You'll find all of our social media accounts. And let me just say, in terms of parting advice, attorneys across the country need to know that in most jurisdictions, attorneys can be liable as a matter of law for defamation if they send a copy of a complaint they signed to a reporter, even if they send the as filed court stamped copy of the document to a reporter. And that's because courts say that the litigation privilege, that privilege to defamation, which applies to our court papers, doesn't apply when we make communications to reporters, because the communication isn't naturally arising out of the court case, nor is it material or pertinent to the court case. I disagree. But the state of the law across the country generally is that attorneys lose that privilege to defamation. So what you say in a court paper, you can't say outside of court without either A, making sure that you say things like, as we allege in the complaint, or as we claim in the complaint. And if you want to get documents to a reporter, give them the docket number, or find another way for that reporter to get a hand on the documents that is not a direct communication from you to the reporter. It's doubtful anyone's ever going to find out, but all it takes is someone to find out. And now you might be defending a defamation claim against you that arises out of the underlying litigation that you had already.
What
Interesting
a good
waters to navigate.
Yeah.
Yes.
And again, you see it's fraught with some sharks.
Yes. And a good little workaround tip too. That's some good stuff right there. Oh, Wayne, thank you again so much for coming on. I knew this would be an amazing topic. We could probably talk for another hour about all of these things because I was thinking of all these amazing examples in my head that I'll have to add to our show notes of things that people could do. So thank you again. Of course, everyone, thank you for listening to this episode and hopefully subscribing to all of our episodes so you don't miss a single one. Find them on any podcast app you love.
And as always, like Wayne did, if you are interested in participating in the show or have ideas for topics that you'd like us to talk about, please don't hesitate to contact us. Thank you again so much, Wayne. This has been a fantastically valuable episode, in my opinion. And anytime that you find yourself in Chicago, please don't hesitate to reach out.
Awesome. Thanks,